respectively. Woolwald showed that attempts were made to introduce amendments to both these articles to Danfee that the embargo in Article 13.2 does not apply to an amendment made under Article 368. Besides, it would appear from the proviso to draft Article 8 before it was deleted if read with Clause 2 of the A article, as also from the note showing the purpose for which it was incorporated, that the law referred to therein was a legislative law. It could not by any stretch of language be construed as including an amendment under draft Artides 04 BC. Kausk, the proviso was making the restriction in Clause 2 of Article 8, one applicable to the state from making any lay for, the removal any inequality, ispari 1 tuis adventac or discrimination arising out of any existing law, if state and law have, be given a particular meaning in the proviso. The same meaning has to be Rev. 2 of draft Article 8 that it is also a legislative law that one's therein referred, pp 475-480, LTL Savananda FL, Kalala 35 on, view taken and having regard to the Majanti decision in Goloknath, that the power of amendment is to be found in Article 368 itself. His lordship did not consider it necessary to go into the question whether he leading majority in Goloknath was right in finding the power of amendment in the residuary entry 97 BF List I of Schedule 7. A. Sankoiri Prasad, Brar, Urtian F. India State of Bihar, 1952, SCR 89 Saijan Singh, V. State of Rajasthan, J96, 1, SCR 933, Gopalan V. State of Madras, 1950, JSCR 87 referred to the word amendment. IQ at 368. Docs not include repeal Parliament could amend Art 368 and Art 13, and also all the fundamental rights. Though the power of amendment is wide, it is not wide enough to totally abrogate or CM3 these or damage any of the fundamental rights or the essential clements in the basic structure of the Constitution or of destroying the identity of the Constitution. Within these limits, Parliament can amend every article of the Constitution. Parliament cannot, under Arty 368, expand IRS power of amendment so as to confer on itself the power to repeal or abrogate the Constitution, or damage, emasculate or destroy any of the fundamental rights or essential elements of the basic structure of the Constitution, or of destroying the identity of the Constitution. The 24th Amendment has not changed the nature and scope of the amending power as it existed before the amendment, page 97, 5 and 12. This court has during the last over 2 decades forged an approach of its own and set out the rules applicable to the interpretation of the Constitution. There is no constitutional matter which is not in some way or the other involved with political, social, or economic questions. And if the Constitution makers have vested in this court a power of judicial review, and while so vesting, have given it a prominent place describing it as the heart and soul of the Constitution, this court will not be deterred from discharging that duty merely because the validity or otherwise of the legislation will affect the political or social philosophy underlying it. The basic approach of this court has been and must always be that the legislature has the exclusive power to determine the policy and to translate it into law, the constitutionality of which is to be presumed. In this regard, the legislature, the executive, as well as the judiciary are bound by the paramount instrument. The bona fides of all the three of them has been the basic assumption, and though all of them may be liable to error, it can be corrected in the manner and by the method prescribed under the Constitution, and subject to such limitations as may be inherent in the instrument. When courts declare law, they do not mortgage the future with intent to bind the interest of the unborn generations to come. The courts have a duty, and H3V indeed, the power to re-examine and restate the law, be within the limits of its interpretative function, in the fullness of the experience during which it was in force so that it conforms with the socio-economic change and the jurisprudential outlook of that generation. The difficulty which foreign cases or even cases decide within the Commonwealth, where the common law forms the basis of the legal structure of that unit, is that they are more often than not concerned with expounding and interpreting provisions of law which are not in pari materia with those we are called upon to consider. The problems which confront those courts in the background of the state of the society, the socia and copomic setup, TI1C requirements of people with a totally different ethic, philosophy, temperament, and outlook, differentiate them from the problems
and outlook which confront the courts in this country, it is not a case of shutting out heat,